NBS Frontline. The race to amend the UPDF Act is underway, with justifications from the government now before the August House.
To move that the bill entitled the Uganda People's Defence Forces Amendment Bill 2025 be read for the first time.
Rules of procedure gives us 45 days to process a bill. For you, Mr. Chairman, a bill introduced yesterday, and you say it must be ready by Friday.
This move responds directly to the Supreme Court ruling and risks setting nationals against the very force meant to protect them.
Members through various platforms so that they can be able also to bring in their views.
Under the pretext of officially constituting the court-martial, opposition members whose supporters have already faced the court-martial's harsh scrutiny remain deeply skeptical.
Try to take us back, we civilians, into the kangaroo courts is heartbreaking.
Is acting mischievous, and I mean acting in bad faith.
The pressing question remains, will those whose cases were transferred to civilian courts be brought back to the General Court-Martial?
Your committee, that you give ample time to the general public to come and express their views.
The rush to table the amendment sends a chilling message to opposition politicians, especially with the general elections looming. Will the security agencies heed their commander-in-chief's advice or not? How deeply embedded is Museveni's high command in these signals? This is The Frontline. NBS Frontline.
Oh yeah, it's The Frontline, and a very warm welcome. Good evening to all our viewers out there. My name is Simon Kagwanjala. Well, over the past few days, the country has been embroiled in a very fierce discussion around nothing but the UPDF Amendment Bill 2025. The most contentious clause speaks to the reinstatement of the trial of civilians before the court-martial. Well, several voices have weighed in. Lawyers have argued across the aisle with a stance that perhaps this could be in violation of the Supreme Court ruling of January 31st that overturned the trial of civilians in the court-martial. Other voices have spoken otherwise. Beneath all this is an ongoing discussion in Parliament. The clerk to Parliament issued an invitation for stakeholders to make their contributions, but it was also mired in a bit of mystery. That views would only be collected for a day, submitted for a day. What does all this mean? There have been queries about the haste in the manner in which this matter is being presented and discussed on the floor of Parliament. And there have also been quite a number of concerns that we'll be interrogating tonight. My guests are Counsel Enoch Barata, NRM's legal advisor. I have Counsel Nicholas Opio, a constitutional and human rights lawyer. Andrew Mwenda, the old man, joins us, a senior journalist. Sorry? Of the clan. Yes, thank you. He joins us as a senior journalist to share his perspective as well. Dr. Miriam Matembe, a very senior politician, a mother and a civil society activist. Oh, thank you.
A citizen and a child
Plus,
of God.
Our panelist, Honorable Semuju Ibrahim Nganda, Member of Parliament for Kira Municipality. It's a full panel tonight. Let's delve into business. A very good evening to all panelists, and nice to have you.
Thank you.
Honorable Semuju, I'll start with you. Appraise us on how the debate has so far been in Parliament, with all the questions, the opposition, and the dynamics?
First of all, the UPDF amendment bill had been in Parliament before, proposing, among other things, to elevate SFC to a level of a force, because in the old law, if you read Article 210 of the Constitution, the lawyers can correct me if I'm wrong, that article gives Parliament power to make a law to regulate the army, which it did in 2005. And in that law, Parliament created land and air force as the force of UPDF. Since 2005, we have had initially a brigade protecting the president, elevated to a special force, but it was at the level of the land and air force for a very long time illegally. I was sitting on the Committee on Defense. I raised that matter at one time, and the Minister of Defense, then the Honorable Crispus Chionga, he took leave to go and bring a legal explanation. He never came back. So SFC, when UPDF was doing their organogram, they put the CDF and then put commanders of the forces, land, air, and SFC, even published. So I asked them, what is the status and level of SFC? Then they couldn't. So the earlier amendment was seeking to elevate SFC, to regularize, to validate to a level of a force, but they are also trying to create another force, I've forgotten the word, veterans. And then they are making provision for other, what ordinarily should be administrative issues in the army, until the Supreme Court ruling. So they took a decision to withdraw and then brought it back with clauses that are seeking to restore the now outlawed military courts. The Speaker said the two committees of Parliament, one on legal. The legal committee usually has a number of lawyers, and then the defense committee will scrutinize this bill. Unfortunately, I don't know that is an order from President Museveni, but it looks like it is. The Speaker said this bill must be completed very quickly.
In how words?
Yes, because she said this is a straightforward, and I asked her, but you can't be the one calling it straightforward. So the committee started sitting the following day, and because Parliament has finished
it was budget, tabled on Tuesday.
Tabled on Tuesday, yes. Tuesday, Wednesday.
Tuesday.
Yes. And the committee has been sitting for the last 2 days. This has been a very busy time when we are handling budget, but this committee continued sitting, and strangely the clerk to Parliament publishes a notice in the Gazette calling leaders of political parties to appear before the committee. That notice must have been published Tuesday evening, and they were required to report to the committee Wednesday morning, and they were being given only 1 day. So the opposition complained about that matter. So since then, we have had a number of appearances. So the two committees continue. But there will be a sitting of Parliament on Tuesday. It looks like, because Mr. Museveni has called the NRM Parliamentary Caucus to interview on Monday, the way I know the goings on around Parliament, do not be surprised when you see a report. Because what happens in Parliament sometimes, government writes reports for committees of Parliament, and MPs are just given reports to come and read. Mm-hmm. Yes, they do that. So don't be surprised that on Tuesday you will see that committee walking to Parliament, because it's common now. I sit on the budget committee. MPs are someone to come and sign a report they have not read. There's one lady asked today that assuming someone asked you in Parliament, what is on page 3, what would you say? And she was just laughing. So it's possible that even the report is being prepared, you may have rules suspended.
So there is a sense that the opposition, the opponents to this bill,
the victims
are fighting a losing battle.
The numbers in Parliament plus the military, because if you put up a battle, at least they have been in Parliament twice. The military has raided, beat us, and arrested MPs from Parliament. So if Museveni wants it passed on Tuesday, it will be passed.
Thank you. Nicholas, you've been quite outspoken on this matter. You've stated your position from the legal perspective. Do you imagine this is a fight in futility for you? And so far, what are your observations on how the entire process or the entire bill is being processed?
So thank you very much. As you said, I've said many things about this law on social media and elsewhere. My view is that we have to look at this bill in two sections, because there's a section that is actually very good that seeks to address the question of access to health care for soldiers in military service and those who have been maimed as a result of their service. That is something you can't argue against, right? There are provisions that seeks to provide a legal structure for the SFC in the structure of the armed forces. Because in essence, the SFC has been an illegal entity within the UPDF structure. You can't argue against that. So there are good things about the bill that I think we shouldn't lose track of in this debate. The second part is where the controversy is, which is the attempt to try and comply with the directions and the orders of the Supreme Court. In that regard, that section of the bill is in direct variance with the orders of the Supreme Court. It is seeking to reintroduce the status quo that the Supreme Court, in fact, nullified in their judgment. And that is a part of the bill that is concerning for me in so many respects. The Supreme Court said that the ordinary rule, the general rule, is that everybody, soldiers included, must be tried in criminal proceedings before civilian courts for offenses over which civilian courts have jurisdiction. Okay? Secondly, the court said civilians can only be tried in extremely exceptional circumstances. Circumstances that are out of the ordinary. What the bill provides is really the normal course of things. Creating parallel jurisdiction, in fact, in some cases, competing jurisdiction over ordinary courts. To that extent, therefore, that section of the bill really would be in violation of the orders of the Supreme Court. Some might even argue in contempt of the Supreme Court. Secondly, it would be a violation of Article 92 of the Constitution, which clearly provides that Parliament is stopped from enacting legislation to vary a decision of the courts as to a dispute between the parties. The government was a party in this dispute before the Supreme Court. That same government cannot come to Parliament to pass a law that seeks to vary that decision of the Supreme Court.
Is Parliament acting down to the Supreme Court decision?
No, I think there are other intervening interests that have made them care less about the legal arguments that are being advanced against this bill. And you can tell this by the rush in which they want to enact this law. The Supreme Court said, cease trials of civilians and transfer their cases to civilian courts immediately. That wasn't really important for those in charge. For them, what is really more important is passing another law. So you can tell that there is an intervening, superseding political interest that does not pay much attention to the law or the arguments being put against that section of the bill.
Yeah, but there appears every signal that all your noise, all your arguments are in futility.
No, they are not in futility. First of all, I'm not making noise. I'm sharing an opinion as a citizen. To say noise is to say I'm rowdy, just an empty tin. I'm sharing an opinion as a citizen. I don't think they are in futility. I think that the powers that be may have their day. And my encouragement to the MPs is don't speak to the speaker because you're speaking to a rock. Her mind is made up. Speak to the record. Provide sound arguments why you oppose this law. Put that on the record because that will be useful going forward, either in a process to challenge the law. And I can give you just one example. That the clerk to parliament invited the organization where I used to work. I've since resigned from there. At 5 p.m. on Wednesday to appear at 9 a.m. on Thursday. 9 p.m. on Wednesday to present their views. Yes, 5 p.m. to appear on 9 a.m. the following day and make a presentation. We simply told folks in the office that is not possible. To have a well thought out, well written memorandum is not possible. Instead, we wrote to the committee to say, oh, we want to give you our views, but the time you've given us is too short. That is not an innocent letter. We are speaking to the record to say that the process of passing this law is not paying due regard to the concept of public consultation. One of the experts on military justice, somebody who has a PhD in military justice, is the Dean of the School of Law, Dr. Ronald Naluwairo. They wrote to him 5 p.m. the day before, being asked to appear 9 a.m. the following day. The Law Society was given 2 hours. They were served a letter in the morning of the same day to appear at 9 p.m. So really, public consultation is not being taken as a serious matter on a law so consequential. So my request to MPs is, they may pass the law, they have the numbers, but I don't think they have the sound legal argument and the moral argument to pass a legitimate legislation. So speak to the record and make sure that that record is clear.
Before I move to Council Barata, in your reading of things, do you imagine members of parliament on both sides of the aisle have a clear grasp of what this bill entails?
I don't think so. Watching the debate, I don't even think many of them have read it, to be honest. I don't think many of them have even read it. Because if, for example, you look at Schedule 7B of the bill, which defines military attire, or what they call equipment and attire, the preserve of the UPDF. They include things like, ammonium nitrate. If you go to any commercial agricultural farm in this country, if you go to any stone quarry, to any chemistry lab, they have ammonium nitrate. That is now becoming a preserve of the armed forces. And if you're found with it, you can actually be tried. They define Kaunda suits. They even put a picture of a Kaunda suit. As long as it is coffee brown, it is navy blue, and I forget the third color, it is the preserve of the armed forces. Without reference to any insignia, any Kaunda suit of those colors. Now, those things must really upset anybody who reads it to say this is not right. And yet, none of the MPs have talked about it. The only person who has spoken about a pistol, which is really not the preserve of the armed forces, because ordinary citizens, like all of us here, can acquire a pistol through the Firearms Act. It is not a preserve of the armed forces. So many of the MPs haven't read the law. I really invite them to read the bill that was tabled in Parliament in November of last year, which was withdrawn. Read the current bill. Read the voluminous decision of the Supreme Court of all the 5 justices, and see what they decided. But do yourself a favor as well and delve into a bit of our history and look at the role of the armed forces, really in the governance of this country and how that has been a problem. If you did that, you would have a more informed debate.
Thank you. Councillor Barata, the writing on the wall points to a very desperate attempt by government to pass this bill at any cost, including reports that MPs from the NRM have been summoned on several occasions to support the bill. 2, there have also been reports of MPs being bribed. And now here we are, even with the voices that are coming from legal minds. Government or the NRM sounds totally deaf about it. Don't you think there is need for further reflection on this law? Or could it be lost in politics?
Okay. Thank you, Simon, and I'm happy to be on this show for the very first time. I have the pleasure of sharing the stage today with the distinguished and senior debaters here. Now, I came here, I drove from Chadondo. We're in the middle of some
Chadondo is the NRM party headquarters.
We're in the middle of some electoral processes. And while driving here, I was conscious of the new traffic rules that came into force. So I tried to drive at 30 kilometers or less per hour. And it took me, on my count, 43 minutes. So I got actually more than 43 minutes because I left Chadondo at 9 o'clock and I literally rushed into the studio here. Now, that means that anybody driving in any direction of Kampala, 10 kilometers into Kampala, will, on top of the regular 1 hour slowdown, be slowed down by a further 1 hour. That's 2 hours. So I don't know what it will be for outside Kampala. The point of that is the new traffic regulations, the new traffic law, is a typical example of a piece of legislation that debilitates systems, that completely creates ineffectiveness under the guise of creating safety on our roads. My view is that we must not permit the UPDF Act to be made such an act, that in the guise of creating some sort of imagined safety nets along some lines, we must not make the UPDF Act an act that debilitates our security infrastructure and effectively creates the breakdown of the state. The act, as has been acknowledged, the amendments, all amendments, except a few, were already before Parliament, and they spent there quite some time. The bill was only withdrawn because while it was still before Parliament, the Supreme Court rendered its decision. And so it would have been futile for the bill to go on and pass into law, and then you have to now come back with another amendment bill immediately. So it was all withdrawn, add in the new amendments that are necessitated for compliance with the Supreme Court decision, and then present it at once. I therefore do not think that the debate on the bill is rushed. There are only a few sections of new amendments that are new. The others have been around for a while, And if our parliamentarians who are saying they have not read, had not read it all the time it was there, then even if they are given another 5 years, they are unlikely to read it.
So what do you think is causing all the hysteria?
The hysteria is really perhaps a lack of understanding of what is in the bill, and it is also a significant misunderstanding which has prevailed, surprisingly, of exactly what it is that the Supreme Court decided. Perhaps the most fundamental thing that the Supreme Court decided was that the court-martial, the General Court-Martial, was a court properly and constitutionally established within the interpretation of Article 129 of the Constitution. The court directed that the configuration and setup of the court-martial should be changed in order for it to be able to deliver the guaranteed fairness of trial that is required by the Constitution. So that is the fundamental thing.
Was that the pronouncement of the Supreme Court?
Absolutely, 100%.
Okay.
And anybody can read, you can find that out. So that is very fundamental. So from then on, the question is, how then do we reconstitute and reconfigure the court-martial to deliver the fairness of trial that complies with the constitutional requirement? And I believe I have read the bill, I have read those provisions, and I believe they properly enforce and comply with the directives and orders of the Supreme Court.
Can
I want to bring in Honorable Matembe.
If you can allow. In the meeting today, I think some lawyers appeared. The question of separation of power came in. The judiciary is an arm of the state. And the lawyers, including the lawyers on the committee, built a scenario that the executive, in this case the military, cannot take you to court where there are the prosecutors, there are the judge, there are everything. And they said the decision of the Supreme Court could not have ordered that someone who has taken you to court is the judge, is the complainant, is everything. And the argument on the separation of power persuaded many MPs to believe that actually there is a bigger problem than that, what they were seeing at the beginning.
Thank you. Honorable Miriam Matembe, what is your observation so far on the emotions that are emerging and the issues that are emerging in this bill at its stage currently?
Well, I cannot tell you that I've been reading that bill. In fact, if I had the opportunity, I would just ignore everything that is going on, because everything that leaves the Ugandans out, when in fact management and the defense of Ugandans should be about the defense of Ugandans. Because, for instance, the way you've been listening, the fast speed, the whatever they want to pass these provisions, the deliberate, at times I really feel I just get fired up to really, I don't know what to call fire to consume this nation, because you were concerned about the security of Uganda and Ugandans, okay? So you want them to be safe and their nation to be safe. But you make sure that you leave them out into contributing into what they think would make them safe and make their country safe. Then in the end you ask, who are you making this law for? You have listened to see the speed at which it must pass, and deceit. What hurts me is the shameless deceit. You can imagine this clerk to the National Assembly, who has been a long-standing member of Parliament. I was with him in the 7th Parliament. Who should know the Constitution? Who should know what the role of Parliament? Who should know everything? Eh? He just sends letters to people to be invited to contribute onto this law, crucial, important law for the security of Ugandans and protection of our nation. But you tell them, you call them in the night, you want them in the morning, they may not even have seen your invitation, they may not, but you are doing it with evil intent. What I hate is the evil intention with which these people operate. Because they want to say, well, we invited people to come and participate. If they didn't come, that is your fault. That evil intention, which points to the fact that there must be evil mind, evil and wicked mind behind the passing of this law. Now, having said that, to be honest, I am very passionately angered or annoyed or angry about militarization of this nation in every aspect. I'm very angry about it because I come from a history of suffering because of this military. And to see that the hope which I had in the liberation of this country when NRM, National Resistance Movement, came to power, to see us every single day going in reverse gear is so painful. Now, there is a constitution which establishes the principle of separation of powers. There is a judiciary. It is a separate institution. Yes, the law says they must collaborate and work with one another, but each of them has its specific areas of operation and specific responsibility. Now, why shouldn't a military man, even when you commit an offense which is criminal, why shouldn't he go and be tried by the official established courts by this constitution? Why shouldn't he, for instance? Because according to the judiciary, the Supreme Court, they declared this military court as a disciplinary committee. Like every department, every institution, every section, they all have disciplinary committees. Those disciplinary committees are supposed to deal with those areas where those very people employed there have violated or something like that in their institution. But when it is beyond that institution and it touches the nation and other people beyond that institution, then there is judicial system where you must go and get a right hearing. Now, when it comes to non-military people, which this court intends to capture, especially so when we have seen very, very clearly that the intention is directed at arresting those people who are not in agreement with the NRM government. Because for me, this is what really hurts me so much. We are supposed to be a nation which has a democratic governance, where everybody is free to have a different opinion, alternative opinion, and be able to run with it. We are now in the time of elections, for instance. We are in the time of elections. You've seen NRM, they are there choosing their leaders, they are doing it all with all the craziness that I was seeing. But at the same time, the party which has a leader, which is the leader of opposition in parliament, is closed. It can't do its work. Its office shut down. People cannot do. Now, what is this? If you are doing, me, I'm not here to just argue laws and whatever. I look at what is happening in terms of Ugandans and their lives and their rights and as full human beings in this country. This clear law, and in fact why they are in a hurry, I imagine, is they still want to catch up with Besigye. Take him back, maybe, I don't know. Because when Besigye was brought out of the military court, purportedly put in the civilian court, he was placed before a court which has no jurisdiction to do what? To hear his case. And now all they do is showing public that yes, he's here in a civilian court, but with no powers to decide his case. And as you remember, these people had told us very clearly that they had evidence, and I think this man also was saying, yes, I had him
By
here.
This man, you mean Andrew?
I had him here shouting and saying that, in fact, Uganda was already on fire. This man was killing Uganda, and that's why we caught. If they had all these details of the evidence, like they had it by the time they arrested him, where is that evidence? Why don't they transfer him to the right court, which will charge him and will hear his case? So, for us who are outside there, the way we see things, we don't see any good faith, we see wickedness, we see evil, we see all these things planned to really make the military take over this country in every aspect of life, and therefore run it properly as a military government, as anyway it is by way of practice.
Thank you, thank you. Andrew, what's your take on the wide perception and even the way this bill is being processed?
Well, I'm going to speak on 3 points. The first is a warning to NRM and the opposition MPs about history. So, I think in the 1960s, at the height of the struggle for independence, the British government was concerned that people who were challenging it should be controlled using something called the deportation ordinance. So if you brought chaos against the colonial state, they would deport you to Karamoja or Arua or Kisoro. Those days there were no roads to those places, so you would be out of action. So when the government, when we got independence and the post-independence government, rather the independence government of Obote came in, they wanted to repeal that law. Gracie Bingira was the secretary, the all-powerful Secretary General of the UPC. So, but members of UPC worked with members of the opposition, and I think a man called MP Latim introduced a bill seconded by MP Byanyuma, Alex Latim, to remove the bill. So the bill is taken to Parliament, but Gracie Bingira argues persuasively, this is October 1965, that the bill should, the law, it was called the deportation ordinance, should be kept. In February...
I think the law was the emergency detention.
No, that came under the 1967 Constitution. This is the 1962 Constitution. It had called the deportation ordinance. It had been passed by the colonial government. They had gotten people like the Benaisas and others and taken to Moroto or Aru and jailed them there. So it is in 1965 they introduced a bill to repeal it. And actually there was a majority of both KY, UPC and DP members of parliament who supported it should be repealed because it was a relic of colonial oppression. So it goes to parliament. By the time it goes to parliament, there had been a conference in Ugul where Kakong had been booted from Secretary General of UPC, Ibingira elected, and now Ibingira is also Minister of Justice, and argues persuasively against the repeal of the law. And in the final vote, which happened in October 1965, I think, the repeal process took a long time. Ibingira side won. So the law was kept on the books. In February 1966, Obote came to attend a cabinet meeting. And in that cabinet meeting, when they were in the middle of cabinet, policemen entered, special police forces entered the cabinet meeting and arrested 5 ministers. Ngobi, Kiria, Magezi, Ibingira, and who was the 5th one? So anyway, they arrest and take them away. When they arrest them, they take them to prison, they appear in court.
Take them to Karamoja, actually.
Not before then, they appear in court. Actually, the court grants them bail. When they granted them bail, as they are walking out of the court, they at Buganda Road, as they are walking out of the court, have been released on bail, they are served deportation ordinances. And I want to be looking at my grandson Kagwanjala so that these MPs of NRM and whatever can have a perspective. They are served deportation ordinances. And Ibingira said something remarkable. He said, fate is a great joker. It always laughs last. I'm the very person who saved from repeal this deportation ordinance. He spoke it in poetic language, but we could use normal language. I'm the very person who saved this deportation ordinance from being repealed. So he became a victim.
Detention without trial.
The Preventive Detention Act was passed under the 1967 Constitution. But before it, there was something called the Deportation Ordinance. They would serve you deportation orders and take you to Karamoja or Arua or Kisoro. Those were the furthest places, and you would have no access to your constituency. So if you're an NRM MP, I will put you on notice that it is very likely, the way the law is structured, that you could be the victim. But what is important for me, which comes to my second point of this discussion, is that I think where Uganda has reached, we have reached a point whereby I don't think that, first, because Museveni has organized his politics in such a way that he has personal and effective control, or I would say effective personal control over the core elements of the state, especially the infrastructure, the security infrastructure of the state, the army, the intelligence services, the police, has effective personal control over them. And because of that, it creates an unfair advantage for anyone contesting against him. On the other side, the people contesting him, and they don't know whether because it's this, they tend also to militarize the opposition to him. And I think he does this smartly because Museveni is much more comfortable if you attack him militarily. He's a specialist in violence. And if you employ violence against him, that's where he wants you to be. If you take him to a court that is very soft, by court I mean COURT, where you play tennis. If you take him to a tennis court of political competition, he gets threatened and he would need to revert to violence because that's where he is best at. You should read his thesis at Dar es Salaam University. The mistake his opponents do, and other friends of mine in the civil society community like him, is also to be blind to how the opposition structures its politics, to go into Museveni's court. So let me just flash out what the Matemba has said. I am 100% certain, and anyone is free, if they are genuine, to call the British, the Americans, the French, and other Western embassies and ask them, when you received these videos, audios of Besigye, what did you do? Anyone would in Uganda know. They would send them to the laboratories in Washington, D.C., London, and Paris to test them. They did. They found that these were genuine videos. Besigye was planning a military incident.
Why aren't they being adduced?
Please, you don't interrupt me. I want us to have a sober debate. When you listen on the one side, you will never understand where things are coming from, because I'm trying to provide context. You can ask any official of the American embassy or the British High Commission. They will tell you. They tested them. They are genuine. Museveni is not interested in this Besigye case. He's not interested in the issues of the court. He's much more interested in the politics of it. It's a big debate. I don't want to subtract us from this one. He's not taking Besigye to military court or the courts where he's taking him because he wants a criminal trial. He's looking for something political. We can discuss it another day. You are free to invite me. Kyagulanyi and his people, or at least for that matter, in the view of security of Uganda, the intelligence services, Kyagulanyi had some people from 2020. He was sending them to some politician in Kenya there. They're using ex-military, ex-police to train them in violence. These people, they have been, Kyagulanyi claims they have been arrested, but these people said they are abducted. But the people they claim to be abducted, many of these people were taken out of Uganda, taken to Kenya, trained in skills, military skills to attack security services whenever they are conducting operations. And now, I am reporting what intelligence I get from intelligence organizations of Uganda. At least that is their perspective.
You're so privileged.
And this information was, you remember that I have been a journalist in this country for 30 years. In my career as a journalist, I have reported things from the Army High Command. I have reported, I even have a column in the Independent called Intelligence Declassified. I would declassify intelligence. From 1995 up to 2025. So I have always had access to intelligence, and that's what a journalist should do. So they took people to Kenya. I could go into the details of a lady called Gladys and a certain man called Owino or something, who they are radicals in Kenya who were helping them acquire military skills to confront security services. Towards the election of 2021 and after that elections, they had people trained to set off cocktail bombs, to attack petrol stations, to attack different places in order to create instability. You see? So now, you see, you can shake your hand. The moment you don't listen to the other party and where he's coming from, then it becomes difficult for you to bridge the gap. If the two of you are able to talk, you may not change many things fundamentally, but it's always important to understand the perspective from which the other person is coming. So please understand that Museveni is not necessarily looking at Kyagulanyi, and there's a man called Zake, whom he works with, and all these other politicians. I don't want to go into all the names of the activities I've been doing. There's a lot of details about plans and even physical attacks in Kalerwe, in Nansana. There are petrol stations that were attacked and bombed by them. And I'm disinclined to believe that the intelligence organizations are lying. So you remember that the NUP was being organized as a paramilitary organization. You could see the uniforms they were trying, the drills they were trying to do. So it would be wrong for us to assume that the people who run the state are evil people who are only committed to the destruction of the country.
For the record, as we take a break, you want to portray this as more of a Museveni bill, Museveni law.
Yes. So what I want what I want you to know is that you need to understand where the enemy is coming from. So if you're going to make an improvement to that law, if you're going to help a debate in this country and to keep the politics of this country civil, and you say we shall only sit on our side and listen to our feelings. The other side may have concerns. For them, they are liars. We don't listen to them. This is a problem between the Western world and the Ukraine. I think Trump is trying to solve. If you define your enemy as an evil person whom you must destroy, rather than an opponent you disagree with, and therefore you must fight and defeat, you see, then you change the playing field. The playing field gets radicalized, and the two of you are apart, and the final act would be a military confrontation. If this country has real civil society, has mass media, has politicians of great courage, what is needed is to have a conversation. What are the terms of engagement in I have already told you that I believe that Museveni will always want to go back to violence as his last resort. The one thing you should never do is to try to take him to that very terrain where he has a decisive advantage or a crushing advantage.
As we take a break, do you support the UPDF amendment bill?
But Kagbanjala, I have told you here that I have warned NRM MPs. Let me repeat it now. Please be very careful. You may be passing a law that will catch up with you. First a moment. My grandson, Nicholas, spoke very well. He said, you asked me, do you support the bill? There are many elements of that bill that are important that everybody can support. There is one aspect of that bill that we are challenging, and I disagree with it, that civilians should be tried in a court-martial. That if I wear a navy blue counter suit, I should be tried in a court-martial. But I believe that where Museveni is coming from is that you have people in the opposition involved in subversive activities against the security of the state, and that the best way to handle them is through a military court-martial. We can have a conversation.
Why would you use
hold a second.
draconian laws to counter opposition.
So my point, therefore, is how can we, therefore, have a conversation whereby the state and the security services appreciate the fact that we understand this is a danger, we oppose, but this is not the right solution. I'm telling you, you're not going to change the view of security, the NRM and NRM MPs, whom Museveni will call and bulldoze to whatever they want, unless you have such a conversation. But if you say, you Museveni, you are a liar, there is no threat to security, so then you're not talking to each other. You will not change anything about. Remember, Kagwanjala, what I'm discussing is that the law is before Parliament. If you want to influence Parliament, you have to influence the largest party called NRM. To influence it, you must demonstrate that you also understand where they're coming from. Context matters. But if you are totally blind and deaf to their concerns, then you are not likely to achieve anything.
We'll take a very short break. The question remains, as this bill gets billed as a draconian law, repressive towards the opposition, do we need to look at the stakes or the spirit behind it? Good evening.
NBS Frontline. Are you ready to experience the ultimate in live events?
Can you sit? Can you sit?
From local to global, we bring you the most exciting events 24/7. Stay informed with live breaking news.
Habemus Papam.
Keep in the know of what's happening around you and beyond. NBS Live. Live and filtered and missable. Exclusively on Afro Mobile.